My name is Kirsten Hensa, and I'm one of the attorneys with the law firm of KBR. If you're not familiar with the firm has been around for over 30 years. Our main office is located in Pompano Beach, Florida, down in South Florida, but we also have offices in the Palm Beach Gardens, in Orlando, as well as on the west coast of Florida. And I'm a partner and managing attorney of the West Coast office. I have been with KBR since 2010, exclusively practicing in this area of the law for 14 years. Okay, so let's go ahead and jump into our presentation. Let me just pull them up. All right, jumping into the present. All right, let's first talk about your governing documents and the hierarchy of your documents. All right, because what we're talking about today is amending them. So what actually constitutes your governing documents? Well, if you are in a condominium association, your governing documents comprise of your declaration of condominium, your articles of incorporation, and your bylaws. If you are in a homeowners association community that's governed under Chapter 720 of the Florida statute, then you will have a declaration of covenants and restrictions, as well as articles of incorporation and bylaws. Okay. Now, the rules and regulations, which you might have, they're not considered part of your governing documents. They are just what they are. They're rules, they're policies. They are intended to supplement the restrictions already contained in your declaration. Okay. Now, the declaration of condominium or the declaration of covenant is really the document that is supreme. Okay, it is your constitution. It is the contract between the association and the homeowners that bind to the community. Okay, it is the document that is going to contain your use restrictions. Use restrictions should not be contained in the articles of incorporation or in the bylaws. Now, the articles of incorporation and bylaws, they basically set out the corporate structure of your community, right? So it'll tell you who the members of the association are, who are the directors, how many directors must serve on the board of directors. It'll talk about elections, resignations, etc. Okay. Typically, if there is a conflict between your articles of incorporation and the bylaws, it is the articles that control. So when you are amending bylaws, okay, and bylaws are really going to be an extension of your articles of incorporation, make sure that there's nothing in the articles that conflicts with the bylaws. I've seen so many times where even attorneys amend the bylaws and they forget to take a look at your articles, and there's an inherent conflict. Okay, so then we have to go in and correct the conflict by amending the conflicting provision in the articles of incorporation and then recording it in the public records. All right, so we'll talk about the process of amending your governing documents in a little bit, but let's talk about some common misconceptions, okay, of what boards think they have in their governing documents or what they think they can do or have the authority to do. Okay, so first, what provisions are illegal? I mean, essentially, as long as the amendment does not violate fair housing laws, as long as it's not discriminatory, and as long as the amendment doesn't violate any other Florida statute, pretty much an amendment to the declaration will be effective upon recording in the public records, provided you've obtained the requisite approval. Okay, typically you'll need membership approval. Sometimes you might need mortgagee approval, and we'll talk about that momentarily. But what provisions are holding you back or costing you money? So let's take it the first misconception. A foreclosing lender is required to pay 1% of the original mortgage debt or 12 months of delinquent assessment. Is that true or false? Well, it's true in that this is what Florida statute provides under 718 and 720. This is what is commonly referred to as the safe harbor rule, right? But is the association guaranteed to get either the 1% of the mortgage debt or 12 months of delinquent assessments from a foreclosing lender? And the answer is no, you're not guaranteed this amount. It depends at what your declaration provides, okay? So take a look at your declaration. Typically, this is something that you will find in the assessments article, okay? You might have language that says if a lender takes title through their lien foreclosure process, then that mortgagee is not responsible for any assessments that came due prior to the lender taking title, okay? And it might even have language that says that a third-party purchaser that takes title at the lender's foreclosure action also doesn't owe anything to the association, okay? So if you have that language, well, mortgagees and even third-party purchasers have been successful in court in saying, hey, these declarations provide this, therefore we're not responsible for the safe harbor amount in the statute. And courts have granted those exceptions to lenders and third-party purchasers. So the takeaway here is that if you do have that language in your declaration, speak with your association legal counsel to get that language amended out. Instead, you want to put language in the declaration that says that a foreclosing mortgagee will be responsible for the minimum amount that's set forth in the statute as amended from time to time, okay? All right. What about delinquent assessments accrue interest at the rate of 18% and $25 late fee applies? Well, again, yes, this is what the statute provides, but this is not necessarily what an association is guaranteed. So take a look at your governing documents. First of all, with regard to administrative late fees, the authority for the association to charge late fees has to be expressly set forth in the declaration. And I will tell you, after having reviewed thousands of documents in the course of my career, I can tell you that some of the older documents do not contain the authority to charge administrative late fees, okay? So that's something that you might need to add by amendment, okay? And the administrative late fee is capped under both 718 and 720 at $25 or 5% of each delinquent assessment, the greater of either one of those, okay? Now, with regard to interest, if your declaration expressly identifies the interest rate, and some of the older documents typically have a lower interest rate, generally around 10%, then you're basically locked in at only charging delinquent owners a 10% interest on late assessments, okay? You won't be able to charge the 18% that the statute allows you to do, okay? And if your documents happen to be silent on the interest rate, then only then will you be able to charge at the rate provided in the statute right now, which is 18%. Okay, so typically when we see interest rate already set forth in the declaration, we recommend our clients to amend that out and instead add language that basically gives the association the authority to charge interest at the highest rate provided by law as amended from time to time. That way, if interest rates change, well, you already have language in your declaration that will capture the new interest rate. And the same thing with late assessments. You want the amendment to give you the authority to charge a late assessment in the highest amount provided by law without specifically identifying the amount. All right. Once the law changes, the change is automatically applicable to your community. Is that true or false? Well, that is false. And this has to do with what is known as Kaufman language. It's the magic words that are added typically at the end of reference to Chapter 718 or Chapter 720, which is as amended from time to time. So there are two types of changes that are made to a statute. There are procedural changes, and then there are substantive changes. So procedural changes would be changes, let's say, to the election procedures that are set forth in the condominium statute, right? So, for example, right now you have to provide both a first notice and a second notice of the annual meeting for condo elections. Should that process change in the statute, well, that would be considered a procedural change. Substantive changes are changes in the statute that affect vested rights of owners. Okay. An example of substantive change is a change to the condo and HOA statute with regard to leasing. It is probably the only provision in the statute that really speaks to a use restriction. So both the statutes right now provide that if you're going to amend your governing documents to restrict leasing, then those amendments are only applicable to those owners who vote in favor of the amendment and those that take title after the amendment becomes effective. So with Kaufman language, how this applies is that regardless of whether you have Kaufman language or not in your documents, procedural changes will always apply to your governing documents, right? So if the statute changes the election procedure, it will automatically apply to your community, whether or not you have these magic words as amended from time to time. But if you don't have Kaufman language, or let's say if you do have Kaufman language in your declaration, then substantive changes to the statute will apply. If you do not have Kaufman language in your governing document, then a constitutional argument could be made that the substantive changes to the statute did not apply to your community, and that you are basically governed by the statute that was in effect when your declaration was recorded in the public record. So let's take the leasing example, right? If you were just looking to amend your documents to prohibit leasing, right? You have Kaufman language. Well, the statute says the amendment and leasing would only be applicable to those owners who vote in favor of the amendment and those that take title after the effective date of the amendment. So that amendment, once it gets recorded in the public records, presumably it's approved by the requisite number of owners, now you would only be able to apply the amendment and enforce the lease restriction against those owners who voted in favor and those that take title after the effective date of the amendment. If you don't have Kaufman language, then you could arguably say that you're not subject to this change in the statute, and therefore this lease amendment that has been approved by the requisite number of owners applies to all the owners in your community. Now, a caveat to this is that I'm not aware of any precedent in the law that has taken this position. There hasn't been any constitutional arguments made by any association, so the court has not really ruled on this issue. I mean, this is the opinion of the firm that if this issue was presented, you don't have Kaufman language, that you could make that constitutional argument, but again, that has not been tested in court. Okay, so you need to speak with your legal counsel when you're amending your governing documents to see whether or not it would be beneficial for you and your community to include Kaufman language in your documents. Okay. Let's go to the next slide. All right. So another misconception is that all new owners must go through the screening process in the community. That's not necessarily true. A lot of board members seem to think that all buyers into the community have to go through the approval process, or sometimes even tenants. But that's just not the case. There's nothing in Florida statute or Florida case law that gives associations this authority. This is a document-specific thing. That means that you have to go to your governing documents to confirm whether you have the documentary authority to approve or disapprove buyers. What other types of transfers can be screened? Well, you can potentially approve, disapprove tenants if you have documentary authority in your document. And if you don't, you might want to speak to your legal counsel about giving you that authority. You have to be very careful, especially when you amend your documents to give you authority to approve buyers, okay? The language of the amendment has to be written very specific to also give the association rights of first refusal. Many of you may have heard that in the world of community association, and this is beyond the scope of this particular webinar, and I do have another webinar that I do focus specifically on screening and approval process, but the takeaway is if you're amending language to give you authority to approve and disapprove buyers and tenants or any other type of occupants, you want to get with legal counsel to make sure that the amendment is properly drafted and not in violation with Florida law. Okay. Now, there could be language in your governing documents that gives mortgagees protection. Okay. So, for example, while you can't screen a mortgagee that takes title through the foreclosure process, right? The mortgagee that takes title through foreclosure becomes an owner, right? You can't screen that. But if that mortgagee later decides to rent the unit or to sell the unit, okay, maybe your documents, exempt that conveyance or that transaction from the approval process. So take a look, because you might want to catch that transaction and have that the occupant or the buyer or the tenant in that transaction be screened by the board. There's no reason that that particular applicant should not be screened after the mortgagee takes title. And then also check your documents, because they could exempt certain parties from the approval process, such as spouses, children, parents, generally immediate family members, okay? Depending on the type of transaction, you might not want to exempt those individuals from the approval process, okay? But again, the authority to screen and disapprove any applicant has to be in your governing documents, your declaration specifically. All right. The board must obtain a vote of the owners before making any material alteration. Well, that may not necessarily be true. Now, for condominiums specifically, you may be aware that the statute does say, unless provided in the declaration, the association has to obtain the vote of 75% of the voting interest on any material alteration to the condominium, common elements. Okay, so that means you have to take a look at your governing documents. What does your declaration say? Does it provide for an alternate approval method? Maybe it requires a majority of the owner approval. Maybe it's silent, but essentially it is the provision that's in your declaration that is going to control the question of material alteration. You might also have a dollar threshold provision. So for example, your provision might read, for any material alteration that exceeds, 10% of the budget, or let's say that exceeds $100,000, only those alterations require membership approval. So again, if that's your case, then, any alteration that is under that threshold would not require membership approval. So check your governing documents, and you might want to amend accordingly. Now, keep a note that notwithstanding the fact that the statute and your governing documents might require membership approval on material alterations, there is Florida case law that says that if the material alteration, okay, is being undertaken as part of a necessary maintenance obligation of the association, then membership approval might not be required in that instance. Okay, now that is case by case scenario, and sometimes the facts and the analysis can be complicated as to whether the particular alteration falls into the necessary maintenance exception. Okay, so get with legal counsel before you undertake the material alteration, and if necessary, amend your documents beforehand. With HOAs, well, material alteration is not a concept of HOAs. It is a condominium concept. Nevertheless, HOA governing documents might address material alterations or capital improvements, and typically will have a expenditure provision that if you exceed a certain threshold, it might require membership approval. Okay, so if you're in an HOA community, take a look at that. And if you're looking to undertake a capital improvement project, okay, and your documents currently require membership approval, if the expense of the project exceeds a certain threshold amount, then you might want to amend your documents before you undertake the project. Okay. If a pipe in a wall only provides services to one unit, that unit owner is responsible for maintenance. Well, that could be true, but that also could be false. And this is going to also depend on what your declaration says. So maintenance issues are very document specific, okay, for condominiums especially. So take a look at your documents. How does your declaration address maintenance? Okay, you'd be surprised how board members just incorrectly presume that the association has certain maintenance responsibilities or that owners have certain maintenance responsibilities, when in fact, that's just not how the declaration addresses maintenance. Okay, so take a look. And if the documents don't reflect how you currently maintain certain items, then you might want to amend to update your documents to be in conformance with how you currently maintain the community. If there are certain maintenance responsibilities of owners that you want to shift to the association, let's say owners are responsible for maintaining windows, and you've just noticed that over the years, owners are just not keeping up with their obligations. Well, you might want to shift that obligation to the association. But again, that will require an amendment, or vice versa. If the association has been undertaking certain maintenance responsibilities within the units and you want to shift that to the owners, then consider an amendment. A good example is, depending on how your documents are written, owners might be responsible for not only maintaining and replacing their AC units, but any conduits or components of the AC units, even those that might be located within the common elements. So some boards prefer that if the conduits run through the common elements, that only the association maintain those conduits, because you have to go through common element wall, common element piping, etc. So again, that's a discussion for you, the board, to have with your legal counsel, and then amend your documents accordingly. Another point on the maintenance, and this is very important, check your documents to see if you have incidental damage language. Incidental damage means that, let's say you have to repair a common element piping that is behind a drywall. But in order for you to get to the drywall, you have to cut through a backsplash of the kitchen. Well, if you have incidental damage language in your governing documents, then the association will be on the hook for damage to that backsplash. Okay, so speak with your legal counsel if that's language that you might want to have amended. All right, so then let's talk about the amendment process. We've just kind of gone over some slides where I've pointed out some provisions that you might have in your governing documents or that you might want to consider amending. These are just a few examples of some of the more common provisions that I see typically our clients wanting to always amend, but you might have other provisions. You might have vehicle restrictions, or pet restrictions or lease restrictions that you're considering amending, okay? So what is the process of amending? Well, first, both 720 and 718 say that to amend, you have to basically type up the language of the article or the section that you're amending, and you have to designate all your changes with underlines and strike-throughs. So words that you're adding in, you're going to have to underline, and words that you're removing, you'll have to put a strike across the word. There is an exception to this process, and that is if the changes are so substantial that it might hinder the understanding or just confuse owners, then in lieu of underlining and strike through, you can add at the top of the amendment language saying, substantial rewarding of the declaration or the articles or the bylaws, whatever it is that you're amending, and instead put in there, see the original declaration for the original text or words to that effect, okay? So speak with your legal counsel as to what would be the most effective way of presenting your amendments to the membership, because remember, ultimately, your members will need to see and approve the amendment, okay? Now, amendments will typically be approved at a membership meeting, which could be your annual or a special membership meeting, or in lieu of presenting the amendments at a meeting, you might have the option of having owners approve the amendment through a written consent process, okay? With the written consent process, the consent effectively, it works like a proxy. You'll mail out a memorandum with a signature line at the bottom, basically letting the owners know what amendment you're trying to present to them and have passed. And then only if the owners are in agreement with the amendment do they have to sign at the bottom and then return their consent forms. Okay, so owners that are not interested or owners that are against the amendment do not have to return the consent form. Okay. In order to do the approval process through the written consent, you have to have specific authority in your governing documents if you're a condominium. So typically, this would be in the bylaws. So check the bylaws to see if they allow you to have members vote on things through the written consent process. With HOAs, as long as there's nothing expressly prohibiting owners from voting through the written consent process, then the homeowner association can't present amendments through that process in lieu of a meeting. Now, if you are presenting the amendments to the owners at a meeting for a vote, typically owners will vote by proxy if they are not attending the meeting in person, or they will vote in person via a ballot, a written ballot, okay? If you're using the proxy, well, proxies are good for 90 days, starting from the date of the first meeting, okay? And if you don't get the necessary votes in at that first meeting, then you can recess and reconvene your membership meeting as many times as you want, up to that 90-day deadline, okay? And then only at the last meeting, assuming you get the necessary votes, you can then go ahead and adjourn the meeting. With the written consent process, those consents, okay, as soon as you receive the first executed consent form, you also have 90 days to get the necessary consent forms to pass an amendment. Okay, so really with meetings and consent process, you have 90-day window to get your necessary votes. Now, in terms of distribution to the members, your proposed amendments will be distributed to the owners either by mail, okay, or by hand delivery, or by email to those owners who consent to receiving notices by email, okay? So for those owners who have not consented in writing to receiving notices by email, if you email them the amendment, and then the notice of the meeting or consent form, well, that would not constitute an official notification. So you'll have to either mail or you'll have to hand deliver in addition to emailing the amendments to the owners. Now, in terms of the vote tally, well, both HOA and the condominium statute provide that if your documents are silent as to the membership approval that you need to get in the amendments, then you need to get a vote of 2/3 of the owners. Okay, so check your governing documents. What language, what specific threshold is it requiring for you to amend the document? So depending on what you're amending, that's the document you have to go to confirm your approval requirements. So if you're amending the declaration, you need to look at the declaration to see what the percentage vote you need. And typically that would be in an amendment section towards the end of the document. If you're amending the bylaws, then you have to look to the bylaws to see what the percentage vote you need to amend the bylaws, okay? Now, if you happen to have a high threshold vote requirement, for example, 75% of the membership, then as a practical tip, you might want to consider to first present to the owners an amendment to reduce that voting percentage to something that's a little bit more manageable, whether it's 2/3 or a majority, or maybe even a majority of quorum. And then once that amendment gets approved and recorded in the public records, then at that point, consider presenting the more substantive amendment to the owners for consideration, okay? Now, material amendments. There are certain amendments to your documents that are considered material under the statute. And typically those amendments are if you are amending, voting percentages or the percentage by which owners own common elements or percentage by which owners pay assessments, okay? Those types of amendments typically will require a vote of 100% of the unit owners plus mortgagees. Okay, so you can see why it's very difficult to amend, percentages by which owners pay assessments. It's virtually impossible, and I've never seen an association carry that vote successfully. Now, leasing, rental restrictions. I had briefly mentioned that both the condominium and the HOA statute have a provision that essentially says that if you are amending your declarations to prohibit leasing or to restrict the term of leasing or the number of times a unit owner can lease, well, those amendments would only be effective against those owners who vote in favor of it, and then those owners who take title after the amendment becomes effective, okay? So depending on whether or not you have Kaufman language in your declaration, then you'll have to, consider how you're going to apply these lease restrictions in the statute, okay? Assuming you have Kaufman language and the statute applies, you just have to be very careful in tallying the votes and documenting who voted in favor, because that is going to become useful at time of enforcement. Okay, and then suspension of voting rights. I wanted to bring this to your attention because this might be a useful tool for an association to pass amendments. So both the condominium and the HOA statute allow associations to suspend voting rights of owners who are more than 90 days delinquent on a monetary obligation to the association. In the case of condominiums, the monetary obligation has to be at least $1,000 in arrears for you to suspend voting rights. And I'm not going to talk about the specifics of how to suspend voting rights, but if you do suspend voting rights, okay, well, the statute says that the owners whose voting rights were suspended would not be counted towards quorum or towards the percentage of membership approval that you need to obtain to get an amendment passed. So if you have a community of 100 units and let's say you suspend the voting rights of 10 owners, well, the quorum that you would need to get would be based on the 90 owners, not the 100. And then the approval that you would need to get on the amendment will be based on the 90 owners and not 100. So for many communities, that change in the voting interest, might make or break the amendment process. Okay. And I also want to briefly just mention that it's quite possible that depending on the type of amendment you're presenting to the owners, it might require mortgagee approval. And again, that is something that's going to be very document specific. Okay, typically amendments that affect the priority of lien would require mortgagee approval. But I've also seen documents that say really any amendment that would affect the rights of mortgagees require approval. Well, in that case, let's say you're amending the declaration to prohibit leasing. Well, arguably an amendment that prohibits an owner from leasing could affect mortgagees' rights, right? Because once a mortgagee takes title to the unit, well, they are effectively the owner. So just be careful, be aware that there could be that requirement. Both 720 and 718 do provide a statutory process of obtaining mortgagee consent. And if you don't get mortgagees involved in the approval process, well, they have the ability to challenge the amendment if you try to enforce it against them. And they have a 5-year window from the date of the recording of the amendment to challenge it. Okay. All right. And then lastly, I want to talk about e-voting, because we get this all the time. Boards tell me, we'd love to amend, we need to amend, our documents are so old, they're not effective, but we're just having issues with getting quorum or getting the necessary voting requirement, right? Well, as you know, Chapter 720, 718, and then also Chapter 719 give associations the ability, the authority to implement e-voting, electronic voting, okay? And this is probably one of the more positive changes to the Florida statute. And I can tell you for our clients that have implemented e-voting in their process, they've seen amazing results, okay? So something for you to consider. The statute already gives the associations the authority to implement it, okay? But it's not automatic, okay? It is essentially a 2-step process, but fairly simple that boards can do, okay? So the first step really is the board needs to adopt a resolution implementing e-voting in their community, okay? And I want to make it very clear. There is nothing in the statute that requires membership approval for the implementation of e-voting, okay? Whether or not you want to have owners or you want the owners to have the option of voting electronically on any action that requires a member vote, that is a business decision of the board. So if that's what you want to do, you essentially have to hold a board meeting. You notice the board meeting with 14-day notice. So you either have to mail the notice of the meeting or hand deliver it or email it to owners that have consented to receiving notices by email. And then you post a copy of this notice of the board meeting on condominium or an HOA property at least 14 days prior to the meeting. Okay. And the statute tells you the type of resolution that you have to adopt and certain requirements of the resolution. But essentially, once you, as a board, adopt the resolution, okay, the second part to this is owners just have to consent or opt in to the e-voting process. That doesn't require approval. Again, the owners do not have to approve e-voting, but if they want to participate, have the option of electronically voting on any action requiring member vote, whether it's amendments or elections, then all they have to do is simply consent in writing and return a written consent to the association. Okay. Now, once you've implemented e-voting in the community, then The association can present really any action requiring member approval through this process. Owners that choose not to opt into the electronic voting process will just simply continue to vote via the traditional method, okay, by proxy and ballot. And then anyone participating through the e-voting process would also be counted towards quorum. Now, the statute also addresses in a lot of detail as to what the requirements for the electronic platform, what the requirements that the platform needs to meet in order to have a viable electronic voting system. Frank is going to talk about that momentarily, but I think the big takeaway from this webinar, in addition to, consider amending certain provisions that are just not effective or are hindering the ability of the association to operate efficiently, is that you consider implementing e-voting for your community, whether it's to amend documents in the future or elections or for any other action. Okay. So on that note, I just have one more fun slide. Healthcare alert: owning a home in an HOA may be hazardous to your health. And without further ado, I'll have Frank take over.
All right. Good afternoon, everyone. Thank you. Wow, Kirsten, as a fellow person working in the management industry prior to this role and an active board member in my own 450 unit HOA, that was eye-opening. So I can't thank you enough. And certainly for any board members on the call today or even managers or licensed CAMs out there, thank you for joining us. This is a ton of information, at least most of it new to me. And we certainly have, I think, an overview as to what's supposed to happen. But thank you so much for diving into those details. It certainly is so helpful. From my perspective, Frank Valdez, I'm the regional director in the state of Florida for Get Quorum. We are an electronic voting provider in the States and in all of North America, for that matter, servicing over 2,000 communities, many of those in the state of Florida. And so I just want to kind of dive a little bit into electronic voting today. As far as Get Quorum's concerned, let me go back to that slide about our company. Again, just so you know, we are a provider and industry leader of electronic voting, ballots, proxies, electronic meeting notice distributions. As Kirsten was just mentioning, you can get a lot of these notices distributed electronically as those owners opt into electronic notices and electronic voting. And we do provide virtual meetings as well, monthly, board, annual, and even special meetings, which will address a lot of these amendments that were discussed today. So ultimately, servicing, again, over 2,000 communities with over 30 industry experts dedicated to this, really this field and an integration with Zoom. So we'll go to the next slide here. We're going to dive into very quickly here a little bit of electronic voting because we want to get to these questions. I see at least 7 on the chat. And it'll just be a few minutes here, so bear with us. Just a really high-level overview about electronic voting. Look, everything Kirsten mentioned today is obviously very significant for an association. There should be no association in the state of Florida that does not amend their bylaws or governing documents at some point, right? Whether it is newly turned over associations, and I'm seeing those from a developer turned over and a new board of directors taking over saying some of this stuff just doesn't ring true to us, it doesn't apply. Or whether it is an association with 30, 40, 50-year-old documents that say, hey, the way these things were written before, we got to make some changes. The common question we get as an electronic voting provider, having been in the industry since 2015, when the statutes change and allow electronic voting, is how do we get the participation, right? And commonly what we're seeing here is through electronic voting, right? I'll give you some really high-level numbers here. Across 2,000 communities, 70% is the average, on average, for electronic voting. So in terms of electronic voting, what it is, why use it? Look, it's simple. It's an electronic ballot, right, sent out to these owners, or an electronic proxy, making sure that we can walk through that information on a digital level with owners that opt in, of course. In terms of why use it, we just mentioned there's a ton of participation out there, right? We're going to make sure that we get those owners opted in, that we're able to reduce printing and mailing costs. If we get 70% of the owners to opt into electronic voting and electronic notices, they can bypass that official mailer, so to speak. And so you're going to have a massive reduction. Electronic voting is usually going to be budget neutral in many of those cases. Efficiency is going to go through the roof. Everyone's load is going to lighten a little bit as far as county committees concerned, even on the legal counsel and on the board and management, right? Reporting is going to be there, auditability, transparency, and there's a ton of security features on the back end, the likes of which you'll never have on paper. So my suggestion to you is to make sure that you connect with an electronic voting provider that is able to assist you. Go granular into conversations. Let them know you not only have potentially an annual meeting, but also some amendments, right, in the forefront and in the horizon that you're going to be tackling. Get into those details. Make sure it's a full service provider that you're connecting with out there, someone that's going to set things up for you, that's going to provide an electronic ballot or proxy to the owners. And dare I say, even help the association with the second requirement there that Kirsten mentioned, which was, hey, after the resolutions passed by the board, check that box off. You've got to get owners to opt in and consent electronically to receive electronic notices and also to electronically vote. Get some help with that is certainly my biggest advice today, because sending out just a paper, electronic opt-in or consent notice is probably going to render lower participation rates. Try to get a company that's going to assist you electronically getting those forms out to owners, allowing them to electronically opt in to voting and notices. There's a digital way of doing that. And certainly that's the step. So full service, electronic voting, you'll get tons of participation. We've got a wealth of information coming up, not only in our website, but in other, continuing education courses that we're going to provide. And I think we can go on to the next slide here, because I'll just leave it again from a high level overview here. All right. So contact us if you need any more information. It's there. Again, we'll be providing some more courses for you, getting more granular information into electronic voting. I'll kick it back over to Mark after that. And thank you again.
Okay, awesome. Thank you, Frank. Thank you, Kirsten. That was some great insight. And for everyone on this webinar here today, as Frank was alluding to, we actually will be hosting another collaborative CE session, this time in person. So you'll be able to meet Frank and Kirsten in person in Lakewood Ranch. So if you're in the Lakewood Ranch or Sarasota area on May 2nd around 9 a.m., we're hosting a CE accredited breakfast and learn on electronic voting and virtual meetings for Florida condominiums and HOAs. We'll definitely send some more information at a later date and look forward to seeing you all there. But before we get into the Q&A, I'm going to hand things off to Matt once again to announce the special winner of today's raffle.
Thanks, Mark. Just quickly, I should mention, a lot of times these declarations, these bylaws, these government documents are very old. Sometimes they've been scanned and, are not necessarily searchable, even if you try to convert it. So actually something Minute Solutions does for a lot of clients is to take those old documents and kind of retype them to put them into a much better format. So just want to mention that just in case that is something you're interested in, we can assist with that. Before we jump over to the questions very quickly, Mark just pulled the winner for the raffle for the $50 Amazon gift card, and happy to say that the winner is Cindy Galliette of the Castle Group. So Cindy, I will send you a quick email just to confirm, make sure I have the right email address, and then we'll send that over to you. So thank you very much to everyone for attending, and congrats.
Awesome. And thank you, Matt. Okay, everyone. So if you haven't seen already, just a special note that the evaluation form that Jeff went over at the beginning of today's presentation is available now in the chat box that you should see at the bottom of your screen. Be sure to click it, fill out the evaluation so you get your certification and credit for today's session. But without further ado, we'll move on to the Q&A portion. I see a few questions coming in, actually a lot of questions coming in. So I will go through them. We'll start off here with George. I believe this is one that's more directed for you, Kirsten. And George is asking if an HOA declaration states that the board may not spend more than, say, 20% of their annual budget on special items without a 2/3 owner approval. But if such an expenditure is necessary to maintain the common asset, such as a sustainable improvement or substantial improvement to an aging clubhouse, does the board really need an owner vote?
I mean, it's hard to give an opinion without looking at the governing documents, but typically, if your documents requires membership approval on a special assessment, again, that could fall under the necessary maintenance exception, where you could undertake the the improvement or the maintenance without getting membership approval, right? That's very different from material alteration. So, for example, you can have a necessary maintenance to replace the roof, right? And typically, if there's a requirement to get membership approval and a special assessment for that, I think that is a scenario that would be captured on that case law exception. But if you're looking to, in the process of replacing the roof, replacing, let's say, the color of the shingles or the type of roof, that could be a material alteration. And for that, you might still be required to get membership approval.
All right, awesome, Kirsten. So just going through some other questions. I have a question here from Albert. He's asking, is there a state statute requiring document updates?
No, there's no state statute requiring it, but I mean, if your documents are over, 20 years old, a lot has changed from the time your documents were initially drafted. So definitely would recommend getting with counsel and overhauling your documents.
All right, awesome. So we have a question here from Deb, and the question is, must your documents refer to Kaufman language specifically, or can it say the community reserves the right to change rules from time to time?
Well, remember, rules are very different, than your governing document. So you don't necessarily need to have the word Kaufman appear in your declaration, but you need to have the words amended from time to time after reference to either chapter 718 or 720 or 719. Okay, those are the magic words you need for Kaufman.
All right, awesome. So we have an anonymous question that came in, and this individual's asking, or they're saying that their 90-unit community has always been considered an HOA. Now with the new board elected last year, they have been changed to a COA. Would there be a good reason to do this?
Well, I'm not sure what they mean that they went from HOA to condominium association. So I can't really specifically comment on that. Would it be a good reason to switch? I'm not sure. I mean, that really depends on the community you have and what your current documents say. So that's more of a specific question for your current legal counsel.
All right.
If you have one. And
Awesome.
if not, I know a good one.
Awesome. So just going through some stuff. Thank you, Jackie. She's just saying, confirming what Frank says, our condo participation jumped 97% when using electronic voting. Just showing the power of electronic voting, the opt-in to get stuff like your docs amended when you have to do those votes. So always great shout out. Question for you, Frank. So George is asking, if I actively decide to opt in for electronic voting, does that mean I also have to opt into electronic notices?
So very good question there. First and foremost, no, there is a separation of those two consents. There is a consent for electronic voting in any given community that allows you as an owner to consent or opt into electronic voting. And separately, there is a consent for electronic notices, specifically governance-related notices as well, and annual meeting notices. So there is a separation of that. And in many cases, they really go together. My recommendation would be that the association make a recommendation to the owners that they opt into both. Many of the electronic voting platforms are going to want to communicate to owners, whether it's sending them a link or sending them some other documentation by email and by electronic means. And it really is the complementary product to the other. But no, you do have the right to opt into one and not the other if you wanted to.
All right, awesome, Frank. Another question for you, Kirsten. Ingrid's asking, does the board have the right to approve bylaws, or is it up to the membership?
Well, again, that's going to be document specific. So you're going to have to take a look at the bylaws to see what the approval requirements are. Typically, amendments to the bylaws or declaration or articles do require membership approval. So you'll need to confirm that with your documents.
Okay, awesome. Another question coming in, this individual is asking or stating that they have a townhome and part of their driveway is cracked or damaged. They want to know, is their HOA responsible for this? It was like this when I purchased the home last year. So I'm assuming they purchased the townhome, there's a crack in the driveway. They want to know if the HOA is responsible.
I mean, there's no way for me to really give an opinion on that without looking at your documents. So the
Right.
documents are really going to dictate maintenance responsibility in that case.
All right, awesome. For you, Frank, Gail's asking, once a board approves e-voting, can a new board revert back to mail-out ballots and disregard the e-voting?
So interesting question. Thank you for that, Gail. Surprisingly, the board of directors really has a decision on when they want to use electronic voting for what events, I should say, right? So your question would be, can they revert back? Yes, the board has the decision to state, hey, for this annual meeting, we are going to use electronic voting by way of an electronic ballot and offer that as an option. And then, for example, the very next year, decide it's not in our best interest. We're going to send everything out by paper and only allow paper-based paper-based votes for whatever reason. Haven't seen it, right? In my number of years here, once they see the participation rates and they certainly understand the usefulness behind electronic voting, I have not seen yet an association that feels like it's time to revert back to the old way. So it's almost counterproductive in our opinion, but they do have the right and authority to disengage with it or not use it if they feel like it's in the best interest of the association. And I'll defer to Kirsten if she feels any different on this.
No, I concur.
All right, thanks.
All right, awesome. So another thing for you, Kirsten, George is asking, an HOA has a clubhouse, bar / restaurant that is also open to the public. The operation continually loses money every month, every year. This loss or subsidy is covered as part of our regular annual dues. Can the board impose an additional annual minimum for food and beverage on owners? And can it ever be imposed with a non-anonymous owner vote?
George, unfortunately, I cannot provide any response to that. I mean, that's very specific to your community. I would have to look at your governing documents.
Okay. And then referring back to, we got a follow-up in regards to the townhome with the crack, and what they're asking, Kirsten, is what documents would they need to determine this information in regards to who's responsible?
Typically the declaration is what will address maintenance responsibilities.
Okay.
So the declaration of covenants or the declaration of condominium, whichever it is that you have.
Okay. Another question come in, one's from Grace, and she's asking, is there a recommended boiler template or boutique condo that a boutique condo could use?
I'm sorry, is there a boilerplate?
A boiler plate,
like a template or an amendment? I mean, I'm not aware of one. I mean, it really depends on what your language of the documents, what you have, what you're trying to amend. So it's really going to be, the amendment's going to be specific to you and your situation.
I would have to agree. In terms of electronic voting, we get that question a lot, Kirsten, too. Hey, is there a boiler template that a community can use for an electronic voting resolution? There probably is somewhere out there in the web, right? There's many, legal documents that circulate around. My recommendation, again, being a provider for almost a decade here since the statutes changed, is please consult with your association counsel. There's very specific language when you put together a legal document such as a resolution for electronic voting that might have some specificity as to your association's needs, right? So like everything else, hopefully one of the big takeaways today is connect with a good association counsel that can guide you through this journey, good management provider as well. And then of course, an electronic voting provider that can really finish out and round off that team for you.
Awesome responses. Okay, question from Tom. He's asking, if a government municipality offers to add what would be a substantial improvement or material alteration on a co-op, which is private property, is the required shareholder vote for the material alterations required?
Again, these are very specific questions, folks, that it's hard for me to answer without taking a look at your governing documents. So you're going to have to speak with your legal counsel or engage one to take a look at your governing documents and then provide a written opinion as to these particular situations.
Yeah. We get the same, don't worry, week to week. We get the same very specific questions about, hey, can I amend the docs? What document do I use for this amendment, whether it's a ballot or limited proxy electronically? And as an electronic voting provider, we let them know, you got to go back to your association documents, read through those, connect with association counsel. Again, make sure you're all on the same page. One hiccup could really compromise the entire process. And there's a lot of details in those documents.
All right, awesome. So there's still a decent chunk of questions here. We'll probably go through a few and then we could hand it off to the respective representatives, just being time sensitive. So for you, Frank, the final question is, what is the general cost of electronic voting? They're looking at 48 unit building.
Yeah, so look, in 48 units, whether it's a condo, HOA, or co-ops, I see our co-ops are on the call today. You're probably only looking at a few dollars per door per year, right? 12 months. Connect with us if you want some more specific information. Our contact information is there. But generally speaking, the cost of electronic voting is going to be offset by the reduction in printing and postage and the mailers from the owners that usually opt into electronic voting and electronic notices. So budget neutral at worst for most, if not all, electronic voting processes throughout the year. Costs should never be a factor, especially when it's usually budget neutral. The results will be eye-opening for you as a community. So get more information and get into more specific details. But yeah, a few dollars per door per year in the general is kind of what most associations can expect to pay, give or take.
All right, awesome, Frank. And two more for you, Kirsten. There is still a few other questions, but they seem long-winded and probably better to address on a personal level. So the first of the final two is from Delora, and she is asking, is it important to reinstate the governing documents to remove developer provisions?
I mean, if you're looking to amend only the developer references, I don't think that I wouldn't do it. It still takes a lot of hours just for, to go through each reference and then strike it through. So if you are, doing an, amended, restated declaration and substantively changing it, then it might be worthwhile while the attorney's drafting, just remove those references. But I wouldn't just undertake an amendment process to remove developer references. It doesn't hurt anything because the developer hopefully is no longer involved in the community.
Great feedback. Focus on the details, what you're saying, right? If they have an issue with one of those, obviously, languages in there that's specific more so to processes in that community, then they might want to seek some changes. And that's what we usually see on our end.
All right, awesome. And final question for you, Kirsten, before we wrap things up today. And someone is asking, do the statutes address how much HOA fees can go up, or will this be addressed in documents?
No, there's no cap in Chapter 720 as to how much assessments the association can raise. And there really isn't a cap in the condo statute either. What the condo statute really says is if it exceeds a certain threshold, then it gives the owners the option to adopt an amended budget. So, in our opinion, the board has a fiduciary obligation to maintain the common elements. And so raising assessments, if that becomes necessary, that is just part of the process of, funding your maintenance obligations. So.
Awesome, Kirsten. And thank you both, Frank and Kirsten, for the fantastic presentation today. We hope that everyone on today's call enjoyed it. Just a friendly reminder before anyone logs off to be sure to fill out the evaluation that Jeff had provided in the chat. This will give you access to the questions you need to answer in order to obtain your certification for today's session. And a friendly reminder for those who are in the Lakewood Ranch and Sarasota area to join us on May 2nd for our upcoming CE in-person breakfast and learn on electronic voting and virtual meetings.
And Mark, is it okay if I, before you actually sign off, can I go over it one more time for the latecomers?
Absolutely.
Thank you. Folks in the chat area, not the Q&A, but in the chat window, if you don't have your chat window open, please hit the chat icon at the bottom of your Zoom interface. I'll put the link in there one more time. Okay, so in the bottom of the chat interface, you have your link. When you click on that link, it will take you to a new tab in your browser. This is the evaluation. Not as daunting as it looks. It goes rather quickly. Please fill that out. Hit submit. After you hit the submit button, a new tab will open up with what is hopefully a submission confirmation screen of a successful submission. This forms your certificate that you can save or print instantly. Right underneath it, it's an active link to click here to print it or save it. Click on that. Your printer dialog window will open up where you can choose your printer or your PDF application. If all else fails, you could, of course, take a photograph of it with your smartphone or use the print screen button on your PC. If you're on a Mac, it is Control, Shift, and the number 3 at the same time, and then you can paste it onto a blank sheet. Within this boxed area, click here for your slides, and the slides used by Kirsten for the course credit portion of the presentation will open up in yet another tab, and you can either download it or print it there. And if you have any issues, of course, just email any one of us. If maybe you don't have a printer, can't figure it out, we'll be happy to help. Back to you guys.
Awesome. Thank you, Jeff. And okay, everyone. So that's a wrap for today's session. For those who we weren't able to get to your questions, please feel free to reach out for a more personal dialogue with either Kirsten or Frank to better address your questions. And without further ado, we want to thank you all for attending today's session and wish you all a wonderful day.
Thank you, everyone. Thank you, Kirsten.
Thanks,
Have an awesome
everyone.
day.